Hello, my name is Sarah. Welcome to C.H.I.P.S Court. We are here to help you understand your upcoming court hearing. This video was designed to help walk you through the process that you are most likely not familiar with. It is important to know and understand why you are here. Wisconsin Chapter 48 deals specifically with C.H.I.P.S Court proceedings and lays the groundwork for what has brought you here today. We have gathered legal research, we have consulted attorneys, and we are bringing this information to you as a tool to help you through this process. Thank you for watching, and good luck.
What does C.H.I.P.S mean?
C.H.I.P.S Court stands for Children in Need of Protection or Services. The number one statutory goal of C.H.I.P.S Court is to reunify the child or children with their parents. The reason that C.H.I.P.S Court is getting involved is because there is some concern for the health, safety, and welfare of your child. The purpose of C.H.I.P.S Court is to make sure that your child is in the safest environment that he or she can be, and the main goal is to get those that may be struggling with underlying problems within the home the necessary help to create a safe environment for your child to be able to reunite them with you. The ultimate goal is to work toward the best interest of the child's well-being. The C.H.I.P.S Court process may seem a little intimidating, and that's why we are taking the time today to explain the court process, the timelines, resources, and all of the involved parties along the way.
Why am I here, and how can my child be taken away from me?
Someone has made allegations that they suspect your child has been abused, neglected, or is otherwise in need of help. At the present time, the Department of Health and Human Services feels that you or your child need additional protection or services that can be offered by the court. Children may be removed from the home because the county believes your child is suffering from an injury or illness, or because an order has been issued by the court to take your child out of your home, or there is a belief that your child may harm themselves or others. Because of the determinations, a petition has been issued, and you are now beginning the C.H.I.P.S Court process.
What is a petition, and do I get a copy?
The petition explains in detail what allegedly happened and what information Human Services has gathered. Hopefully you have received this document in the mail. If so, read it carefully, and if you do not understand the meaning of something in the petition, you can ask for help from the courts or your lawyer.
Do I need a lawyer? What if I can't afford one?
Although you are not required to have a lawyer can help you better understand what is going on in court and explain to you your choices and options moving forward. A lawyer fights for your wishes and what you see as the best possible outcome. If you cannot afford a lawyer, you can ask the judge to appoint one for you. An application to get a lawyer appointed is available for you at the probate office in the courthouse. The probate office is located on the third floor of the Douglas County Courthouse, room 304. At the counter, you can ask the clerk for a form to get a lawyer appointed in a C.H.I.P.S case. In order to be approved for this process, you must include verification of your last 2 months' income. If you receive any type of public assistance, you must also provide proof of that assistance. Please remember that this form must be signed in front of a notary.
Who is involved in the process before and during C.H.I.P.S Court?
Some key figures involved in the C.H.I.P.S Court process are the following: a representative from the Department of Health and Human Services. This social worker's job is to bring information about danger your child may have to the court system and to provide services to you and your family to keep your family safe. Another figure is the prosecutor. Her job is to prove to the judge that you or your family is in need of protection and services due to issues of danger or safety in your house. The guardian ad litem's role is to be an attorney for the best interests of your child. The guardian ad litem will meet with you and your family and your child to give recommendations to the judge about what he thinks should happen to your family. However, he is not bound by what you or your child want. His job is to tell the judge what he independently believes is in the best interest of your family. The judge and court commissioner are the people who make decisions. They decide whether your child should be taken out of the home, whether the child is in need of protection and services, and if so, what services can be offered by the court to give to you with the help of your social worker.
What types of hearings are involved in this process?
There are several different types of hearings that may be involved in the C.H.I.P.S process. The first hearing you may attend is what's known as the Temporary Physical Custody, or TPC hearing. If the Department of Health and Human Services believe that your child or children need to be placed in a different environment other than your home while the C.H.I.P.S case is pending, there is a hearing where a judge will decide whether or not that is in the best interests of the child. The next hearing is typically the plea hearing or the initial appearance. By then, you will have received a copy of the petition alleging why your child or children are in need of protection or services, and you will attend that hearing in front of the judge and tell the judge whether you agree or disagree with what is in the petition. The judge may schedule a status conference as the next hearing, giving you time to get an attorney appointed, meet with that attorney, and attempt to look at records to find out what is going to be best for you going forward. If you wish, you have the right to a fact-finding hearing or a trial, where the government and the department would have to prove that your child is in need of protection or services. If you agree with the petition, or if the government does prove that your child is in need of protection or services, then the final hearing is the dispositional hearing, where the judge will decide what conditions need to be met before your child can be returned to your home.
In the event my child is placed out of the home, where will they be placed, and how can I get my child back?
Your child can be placed in the home of you or your child's other parent, a relative or other guardian, the home of a family friend, a foster home, or a group home. There are certain services and programs that the government can provide and that you would have access to that will help you improve your living and family conditions. Your social worker with the Department of Health and Human Services will monitor how you and your family improve, will communicate this information to the judge, and then the judge will decide when your child can come home or when you have completed the services and no longer need the assistance of the government.
The initial appearance is where you will meet with a Douglas County Court Commissioner. A court commissioner is like a judge. The initial appearance takes place at the Douglas County Courthouse. The address for the courthouse is 1313 Belknap Street, Superior, Wisconsin, 54880. You will need to arrive on time for your assigned court date. To get to the courtroom from the Hammond Street parking, you enter the front door. When you enter through that door, there will be two staircases, one to the right and one to the left. You will need to take the left staircase to the third floor. Once you've reached the top of the staircase, you will be facing Judge Tim's courtroom. This is not where the initial appearance takes place. Instead, you'll take a left at the top of the stairs and will see another courtroom. This is the court commissioner's room, where the initial appearance will take place. It is very important for parents to make their initial appearance.
When you arrive on the third floor of the courthouse, you will enter one of the commissioner's courtrooms through the metal detector. You will sit at a table labeled defendant with your attorney. If you do not have an attorney, you can ask the court commissioner for one. Your defense attorney is there to make sure you understand the proceedings and to fight for what you want. The prosecutor represents the state, and it is her job to prove the findings of what you are accused of in the petition. The social worker sits beside the prosecutor. You will also see someone typing through the whole court proceeding, and she is keeping track of what is said in the courtroom. When you see people sitting next to the judge, that means they are being called up to the stand to testify, either against you or on your behalf.
To get an attorney, from the top of the stairs, the probate office is to the right. There's a sign that says probate. on top of the corridor you need to enter. Go up to the window and ask the attendant for the forms for a right to counsel request. If you have questions as to how to fill these forms out, ask your social worker for help. At your initial appearance, the court commissioner will ask you several questions regarding how you want to proceed. You have a number of rights you're entitled to throughout the C.H.I.P.S Court process. They are as follows.
The court commissioner will ask you if you want the petition read to you out loud. You have that right. But if you don't want it read out loud, you can waive the reading of the petition.
This question asks if you agree or disagree with the petition allegations. You have 3 options. You can admit to the petition, or you can tell the court commissioner that while you do not agree with some of the allegations in the petition, you do not want to challenge the petition, or you can deny the allegations in the petition. If you admit or tell the court you do not want to challenge the petition, the court will find that your child is in need of protection or services, and you will have another court date in front of a judge, who will decide what services you will need. If you deny the petition, the matter will be scheduled for a fact-finding hearing or trial in front of the judge. If the matter continues to a fact-finding hearing, the court has to present evidence proving that your child is in need of protection or services.
The court commissioner will ask if you want to waive time limits. The commissioner is asking if you want your next court hearing to be within 30 days. If you want to take longer, you can waive time limits, which can give the parties longer to conclude your case. If the petition is contested, the court will schedule the fact-finding hearing no later than 30 days after the plea hearing, unless you have waived time limits. If the petition isn't contested, the court will set a date for the dispositional hearing, which is no more than 30 days out.
You have the right to the substitution of the judge before or after your initial appearance. This means that you can give the clerk's office or the commissioner a letter with a request to change the judge. The typical judge for these cases in Douglas County is Judge Glonick. A request to substitute the judge would require someone other than Judge Glonick to hear your case. You can make this request only once.
You should also be aware that you have the right to remain silent. This means you don't have to say anything, but your silence can be considered by the judge. You also have the right to confront and cross-examine witnesses appearing against you. This means the people saying you did or did not do something must typically be in court at your trial, and you have the right to ask them questions.
You have the right to present and subpoena witnesses at trial, which means you can give paperwork to someone and make them be at your trial to testify, even if they do not want to be there.
You have the right to a jury trial. If you want a jury trial, you must request one either at or before the initial appearance. You have the right to have the allegations of the petition proven by clear and convincing evidence. You don't have to prove the prosecutor and social worker are wrong in what they are claiming about you or your family situation. They have to prove that they are right.
The more you work to complete what the judge orders you to do, the faster and more smooth the process will go. Remember, the purpose of C.H.I.P.S Court is to reunite you with your child or children and get you the necessary help you may need in order to create a safe environment for the child. Remember to always consult your lawyer or social worker for any questions you may have with regards to your initial appearance.
Your next hearing is called a status conference. The purpose of this hearing is for the judge to check in with everyone to see if an agreement has been reached on how to proceed in the case. The people that will be present during the status conference include yourself, your defense attorney, social worker, state prosecutor, and guardian ad litem.
The judge will ask you if you admit or agree that your child is in need of protection and services, or if you deny or disagree that your child is in need of protection and services. The judge will also ask the guardian ad litem if he or she agrees or disagrees that the child is in need of protection and services. If you deny or contest the petition, then a fact-finding hearing will be scheduled and you will be notified of the date. The parent and lawyer will want to be present for the fact-finding hearing.
Now we will introduce you to the next stage in the C.H.I.P.S Court process.
We will now discuss fact-finding. Fact-finding is the trial part of C.H.I.P.S Court. At the fact-finding hearing, the prosecutor and your defense attorney will argue their case in front of the judge or a jury. Witnesses for both the prosecutor and your defense attorney will be present to help support both arguments for your case. This will give the court a better idea of all the facts regarding the case.
After the prosecutor and your defense attorney have made their arguments, the judge or the jury will come to a final decision about your C.H.I.P.S case. If the court finds that your child does not need the state or the county to step in, the case will be dismissed and you will be free to leave with the custody of your child back. If the judge or jury decide that the county has proven its case and that the child needs to have protective services, then the dispositional hearing will be scheduled.
Before the dispositional hearing, you will meet with a social worker. You are now here at the next step of the court process, which is called the dispositional hearing. At this hearing, the judge will order services. It is completely up to the judge to decide what will be ordered.
The judge has several options available. He or she can order one or any combination of the following for you or your child. 1. Order you and your child to be under the supervision of the Department of Health and Human Services. 2. Place the child in the child's home. 3. Placement of the child in a foster home, group home, or residential treatment center. 4. Outpatient drug, alcohol, and mental health treatment services such as anger management, parenting skills, and other programs. 5. Order other counseling services for the child, parent, and/or guardian. 6. Order a specific educational program for the child.
If your child remains in out-of-home placement, the judge will meet with you and the other court participants within approximately 6 months to make sure all parties are fully complying with the court order so that the child can return to the home.
Thank you for watching our video and good luck with your case.